Judgment in the matter of Evans against Barclays Bank and others.
Lady Rose will explain this judgment.
Collective proceedings are a form of class action that may be brought in the Competition Appeal Tribunal under Section 47B of the Competition Act 1998. Collective proceedings may be pursued only if the tribunal makes a collective proceedings order. Any collective proceedings order must specify whether the proceedings are to be opt-in or opt-out. Where collective proceedings are brought on an opt-in basis, the person appointed to represent the class of people who have suffered loss may pursue claims on behalf of each class member who decides to opt in and joins the proceedings as a party. Where collective proceedings are brought on an opt-out basis, the class representative may pursue claims on behalf of everyone in the class affected by the alleged breach of competition law, except for any class member who opts out by notifying the representative that they don't want their claim to be included. Opt-out claims have procedural advantages for the claimant class and their representative and tend to result in claims which are much larger in terms of value. So if the proceedings are opt-out, this represents more of a threat for defendants in terms of the amount of work that will be involved for them in defending the claim and the amount of compensation they may ultimately have to pay. Mr. Evans applied to act as class representative in collective proceedings to be brought on an opt-out basis. The class of people that Mr. Evans sought to represent were people who had suffered financial loss as a result of infringements of the competition rules by a number of banks who provide foreign exchange trading services to clients. The claims were follow-on claims because they relied on the findings of infringement of the competition rules that had been set out in two decisions of the European Commission issued on 16th of May 2019. Those decisions are known as the three-way banana split and the Essex Express decisions. Those names were the names given by some forex traders to two chat rooms where they met online from time to time over a number of years. But some of the things that they chatted about related to the currency prices that they were setting for customers who were using them to buy or sell foreign exchange. That pricing information should be treated as commercially sensitive information because those prices are how they were supposed to be competing against each other for business. Both infringement decisions were settlement decisions. That means that the banks who employed the chatroom traders admitted that those traders' conduct put the bank in breach of the competition rules in the way described in the decision. And in return for not contesting the allegations, the banks got immunity from the very heavy fines that the Commission imposes for that kind of behaviour, or at least a greatly reduced fine. Mr. Evans therefore applied to the tribunal for an order that he could represent different classes of people who had bought and sold forex, and that he should be allowed to bring opt-out rather than opt-in proceedings. All three members of the tribunal decided that Mr. Evans was a suitable class representative, but two of the three members decided that the collective proceedings should not be brought on an opt-out basis, only on an opt-in basis. In rejecting the idea of opt-out proceedings in this case, they relied on two factors. The first were the merits of the claim. The tribunal held that the claims were weak. This was particularly because Mr. Evans valued his claim at over £2 billion, and no plausible explanation had been put forward by him as to how he made the jump from the limited discussions held in the chat rooms described in the Commission decisions to alleging that those discussions had affected many billions of pounds of forex trading over many years. The second factor is whether it was practicable for the claim to be brought as opt-in proceedings. The tribunal also held that it was practicable for the main group of claimants who bought and sold a lot of forex over the period and alleged that the currency prices that they had offered by the banks had been affected by the chat. It was practicable for them to bring claims for their loss on an opt-in basis. And the evidence showed that Mr. Evans' solicitors had tried to persuade those potential parties to join opt-in proceedings, but they had not agreed to do so. Mr. Evans appealed against the tribunal's decision to the Court of Appeal, arguing that he should be able to bring his claim on an opt-out basis. The Court of Appeal set aside the tribunal's decision on the opt-in, opt-out issue and held that the proceedings should proceed on an opt-out basis. The defendant banks now appeal to the Supreme Court. The Supreme Court unanimously allows the appeal. Lord Sales, Lord Leggett and I give the judgment, and Lord Burrows and Lord Richards agree. The Supreme Court holds that the tribunal was right to assess the merits of the claim as weak and to treat that as an important factor weighing strongly against opt-out proceedings. Rule 79(3)(a) of the procedural rules governing the tribunal's management of collective proceedings specifically identifies the strength of the claim as a factor relevant to the choice between opt-in and opt-out proceedings. Opt-out proceedings give the claimants legal and commercial advantages and expose defendants to additional burdens. If the claim is weak, it's more difficult to say that the opt-out procedure will strike a fair procedural balance between the claimants and the defendants, or that it will provide a proportionate way to give access to the tribunal to pursue the claim. What about the question of how practicable it was for the claimants who had suffered most loss because they did a lot of forex trading to join in bringing opt-in proceedings? The implication of Rule 79(3)(b) is that if it is practicable for proceedings to be brought as opt-in proceedings, then generally they should be. The court decides that the tribunal was entitled to conclude that, looking at the matter overall, it was practicable to bring opt-in proceedings. This is because, first, there was a group of sophisticated financial institutions who had carried out a lot of forex trading in the market and so stood to recover substantial damages if the claim succeeded. Secondly, they had a viable claim which could be brought by way of opt-in proceedings, but they'd not shown any interest in pursuing that claim. It is true that there was also a large group of people who'd only done a little trading and so would not have suffered much loss. And for that group, it would not be practicable for them to pursue opt-in proceedings as a separate group. But the overall value of those small claims was a tiny fraction of the aggregate claim across the whole class and did not justify authorising opt-out proceedings for the entire combined class. And the policy goals of generally helping people vindicate their rights or of deterring breaches of competition law also did not justify opt-out proceedings. The tribunal is required to consider the competing interests of both parties and to strike a balance between them. That is what the tribunal did, and there was no error which entitled the Court of Appeal to overturn their decision. The final issue arose from something that happened in July 2022, after the tribunal had handed down its judgment, but before the hearing of the appeals by the Court of Appeal. The European Commission published 2 further infringement decisions, finding similar infringements in different chat rooms, called Sterling Lads, by different employees of different banks. The infringing bank in that decision did not enter into a settlement with the Commission or admit liability, so the Commission had to make relevant findings of fact to support the finding of infringement. The Sterling Lads ordinary decision, therefore, describes in far more detail than the settlement decisions needed to do about what those traders did and why it was contrary to the competition rules. In its judgment in the present case, the Court of Appeal quoted extensively from the Sterling Lads ordinary decision. It said that the Commission's findings in that Sterling Lads decision could be relied on as showing that the claim against the banks involved in the three-way banana split and Essex Express chat rooms was now shown to be much stronger than the CAT had thought. The Supreme Court holds that the Court of Appeal was wrong to say that. It is a general rule of the common law that findings made by one decision-maker, here the European Commission, are not admissible as evidence of the facts when those same facts are in dispute between a different decision-maker, here the tribunal hearing the damages claim. This is based on the principle of fairness, because it's important that a court or tribunal responsible for finding facts should base its findings on its own evaluation of the evidence presented to it, and not on the evaluation made by someone else on the basis of other evidence presented to them. This is known as the rule in Hollington and Hewthorne, and it applies to the tribunal as much as to any other court. It is true that because of EU law rules, it's not open to the banks who admitted the infringements now to try to deny that they were involved in the infringement set out in a Commission decision addressed to them. But that is not true as regards findings made in decisions against other people, even if the conduct alleged in the Sterling Lads decision is broadly similar to that alleged in the three-way banana split and Essex Express chatrooms decision. The Sterling Lads ordinary decision was therefore irrelevant to the tribunal's assessment of the merits of Mr. Evans' claim. For these reasons, the appeal of the banks is allowed.